Of the consent of the other side, I beg to mention item number 15, my lord. May kindly be taken up after 2 weeks. My lord.
All right. Item number 15 in the prayer of
15, my lord. I have
1-5.
1-5. I am for the respondent railways, my lord. I have taken the consent.
Standing counsel for railways. The consent of the other side. Lays the matter again on.
Except 25, any date. Except
May I please, Lordship? I beg to mention item number 14, my lord. MC appeal hearing.
Item
14.
1-4.
My lord, in this case, my lord, I filed an IA. The case was fixed on 12th of February. The order was passed, but I was not not shown. So I may be allowed to requisite this IA.
Yes.
Lordship, with due consent from other side, I beg to mention item number 17 of today's list, Your Lordship. We are the appellant in this case. I pray that Your Lordship, this matter may be taken up after 2 weeks, Your Lordship.
Same order.
Obliged.
Please, Your Lordship. Lordship, I beg to mention item number 12, Lordship. Your Lordship, respondent number 1A is died, Lordship. Come to knowledge on only yesterday.
Item 12, it is submitted that the respondent number
1A.
1A has expired. Accordingly, time is sought to file appropriate application in this regard. Is the matter again after 2 weeks.
Obliged, Lordship.
Right, Your Lordship. May I mention item 19?
Yes.
This matter arises out of an order of injunction against a temporary injunction passed here at interim. And the party went to Honorable Supreme Court and gave the direction that matter should be heard early. So I'm just praying, we have informed the other side. I'm only praying for upgrading the matter.
Item 19.
My lord.
All right, let them come.
Yes, we have already informed them. Can it be taken up at 2 o'clock so that?
That we can't say right now. Let's see.
Fine.
Maybe, Lordship. I beg to mention item number 2 and 11, Lordship. Matter will be taken up another bench, Lordship.
2 and
11, Lordship.
2 and 11 list the matter before another bench without me.
Yep. 26. Different.
Please, Lordship. Lordship, with the concern of the other side, an item 21 and 23 list, Lordship. Council Ms. R.D. Majumdar is out of station, so Lordship may kindly fix the date as 5th of March, Lordship.
Lordship, I am praying for listing the matter on Lordship 5th of March. Lordship, some urgency is there,
5th
Lordship.
of March.
All 5th of March.
Highly obliged.
Deeply obliged.
May please, Lordship. This petition is for limited period, Lordship. Lordship, what happened, Lordship? There is a title should be pending in the Nagaon, Lordship. There are 3 respondents, 1 and 2, 3. I have taken several steps, and 3 has appeared and filed WS, but 1 and 2 did not appear. I have taken steps, but 1, after taking steps, Lordship, court ordered that to take phase steps. I have taken steps, and I have ordered that it goes to the page number 39, Lordship. May I read it?
Yes.
Page number 39. It is ordered at 14/8/2024. Perusal of the case record shows that the plaintiff has not taken steps for summons upon the defendant number 1 and 2 as directed by the order dated so and so. As such, this suit against the defendant number 1 and 2 is dismissed under order so and so. Thereafter, I
Page
page 39. Lordship.
in 9.
30. First parallel. This pair only.
Yes.
Yes, thereafter I have filed petition that no, I have taken steps and Lordship 1 and 2. Then Lordship page number 20, page number 41. The 26 order was passed 26/3/2025. That that one is already have received notice and
Page?
did not appear, and two and regarding two, my lord may be allowed to take first steps. But Lordship kindly see, by order dated 26/3/25, it has said that the learned counsel for the plaintiff submitted that the instead case is the stage of PW1 and summons upon the defendant number 1 so and so. The learned counsel also submitted that he has taken step for summons upon the defendant number 2 as per direction of the court order dated so and so, and therefore he prayed to vacate the order dated so and so. Whoever suit against the defendant number 1 and 2 was dismissed. The learned counsel also submitted that due to bona fide mistake, he had filed the instant petition after his statutory period and therefore paid to condone delay so and so. Perusal of the case record shows that by so and so, the plaintiff petitioner paid to vacate the order dated so and so on the ground that summons upon the defendant number was served and the plaintiff was taken steps for summons upon the defendant number 2. The said petition under all within the petition so limitation and considering the grounds shown by the learned counsel, delay is condoned and so and so. Record is reveals that by order dated so and so, the suit against the defendant number 1 and 2 was dismissed under order so and so on the ground that the plaintiff has not taken steps directed by the so and so. Perusal of the case record shows that someone upon the defendant number was duly served on 1/1/24. Thereafter, defendant number 1 paid for adjournment on 3/1/2024 to file a statement. But subsequently, the defendant number 1 did not file any attachment. Perusal of the case record also shows that the plaintiff has taken step for summons upon the defendant number 2, but the said steps was taken on 4/11/2024 after the dismissal of the suit against the defendant number 2. So therefore, against the defendant number 2, my steps are waiting. Lordship, my limited power is to give permission to take first step on defendant number 2, Lordship. Because defendant number 2 is the husband of the defendant number 1. If suit is pending, Lordship, only limited power, Lordship. I have already taken, but after
You have to show what is wrong with the order.
wrong, Lordship. I have taken several steps, Lordship. Only one step, Lordship. I have due to my oversight, Lordship. I can't take steps. And it is not that again, 1 and 2, both steps have been taken. 1 has already received. It is that order is reflected, Lordship. Only 2, Lordship. I have always taken steps, but it is not that I have not taken steps. But step was due to oversight, I have taken after the court order, Lordship. Only TSA respond. Therefore, when approach the court has staged the matter and ultimately, Lordship, here is same case, Lordship also. They are not appealing. They are therefore court order dated by 11/2/2026. Court had mentioned that if there nobody is appealing, then Lordship. They are here also not appealing. They are also not appealing, Lordship. After service on Lordship. But I have taken steps.
So what power am I supposed to invoke? What is the illegality or material irregularity with which the court has acted?
Lordship, under 227, Lordship, in and parent, Lordship, but my PR is only to take first steps, Lordship, only. It is not that I am not taking steps, Lordship. If it order starts from Lordship, kindly see, from 23, I have taken steps, Lordship. Page number starts from Lordship 24. Only one date I missed, Lordship. It's not that I am not taking steps from the very beginning, Lordship.
No, what do you mean very beginning? You took steps after the impugned order was passed as against defendant number 2.
I have taken steps only same date, Lordship, but I can't say before the Lordship because it is my fault, because I can't say this record, if record culture record is there, Lordship, but due to, so I am taking the responsibility, Lordship. In the order that it has been reflected. I have taken steps similar date, Lordship, 1 and 2. 1 had received, Lordship, but 2. Therefore, I am taking that I have next due to my fault.
If you took before, how has this finding come that you have taken steps on 4/11/24?
Oh, 1/1/24, Lordship.
No, steps were taken on 4/11/24 as per the impugned order after dismissal of the suit on 14/8/24.
Lordship, actually, I have taken both these steps.
3 months later. you have
Therefore,
taken steps.
delay has been condoned, Lordship. Delay was condoned. I have not seen the order dated, Lordship.
Yeah, on filing the application for vacating the order, that is okay, that has been condoned.
Condoned.
But you took steps against the defendant with regard for issuance of summons on the defendant number 2, 3 months after the impugned order. There were well settled guidelines on invoking the power under 227. It's not to be had for the asking.
Lordship, then I will satisfy, Lordship, Lordship, for the fault of the Lordship, advocate, Lordship, that is petitioner, as the petitioner should not suffer, Lordship. At least I will bring this judgment. For the fault of the advocate, Lordship, petitioner still should not suffer, Lordship. Lordship, it is okay, Lordship, that he due to his oversight, Lordship, and actually, it is
Okay, you do some research. Show us some authorities on this point.
Lordship.
I'd learned counsel for the petitioner. List the matter again on
After
given date.
10 months. Now, after 10 months. Obliged.
By the last order, the appellants were directed to file the amended cost title, inserting the name of the legal heirs of the appellant number 1.
All right, has taken the steps.
My lord,
That has been done.
my lord, substantial question of law is already framed way back in 2017. Matter may be posted for hearing, my lord.
What about this year? It's there. Yes.
Yeah, your lordship.
Here for the respondent.
I am for the rest.
One appears for the appellant, heard learned counsel for the respondent. As per office note, press memo of parties has been received and cause title has been corrected. PCR has also been received, hence is the matter for hearing on.
Visuddhima, all past. Read. 26, my lord, my lord. Oblige, my lord.
IA Civil 3017 of 19. None appears for the applicant or respondent. This is an application for condonation of delay in preferring the review application, connected review application with regard to a judgment and order dated 18/02/2019, passed in CRP number 402 of 2016. This IA has been pending since the date of the first order, that is 30.09.2019. On account of adjournments having been sought by the applicants on different grounds. Is also reflected in the order dated 24/05/2024 that the learned counsel for the respondent had submitted that The decree had already been executed as far back as on 06/01/2020. Therefore, nothing survives. Further, today on call, none appears for the applicant. Consequently, the instant IA stands dismissed for non-prosecution.
Item 5.
Met in Lordship. Lordship, 2 weeks time may be given, Lordship, for take steps. I will take a step today itself, Lordship.
On the prayer of learned counsel for the appellant, further 3 days time is granted to take steps. Is the matter again on
Bless.
May I please? In this case, your worship, TCR has been already received and matter may be fixed for hearing. And also a prayer.
learned counsel for the appellant and learned counsel for the respondent. TCR has been received. Hence, list the matter for hearing.
Worship, can it have on 21st of May?
21st May.
I'm so obliged. Similar prayer, your Lord.
Appear for respondent number 2. One service is not complete.
Service not complete.
We have taken steps. One is the driver on our worship. Maybe step out in Learned Council have.
Please note that 24/2, my lord.
Learned trial court below directed the payment made by the insurance company.
Anyway, we need to have the service complete before we fix it for hearing.
First.
But learned counsel for the appellant and learned counsel representing respondent number 2. As per office note dated 24/2/26, AD card and service report in respect of respondent number 1 has not been received back. Hence, await service.
Since 2023, it has been awaited, your worship.
Take fresh steps then.
Possible. That will be better. Otherwise,
Appellant to take fresh steps for service of notice. Respondent number 1 by speed post with AD and other usual process.
Much up.
Please, your lordship, in this case, madam,
Hmm.
Pushpa Das, who is leading this case here, he did not turn up today, and the case is listed for the first time probably since 2012, madam. One accommodation, my lord, he intimated me, my lord,
Yes, when do you want?
my lord.
When?
10 days, 10, after 2 weeks, sir, any date.
Learned counsel for the appellant raised for 2 weeks' time, since the matter has been listed for the first time after 05/12/2012. So hence list the matter again on
Obliged.
In this case, I am for the appellant, my lord. Reversal finding, my lord.
Sir, বিশ্বাস is appearing other side.
My lord, no, my lord, no one is here, my lord.
Let us wait for some time.
My lord.
Your lordship, kindly pass over the matter for some time.
You are praying for whom?
For the respondent.
None appears for the appellant, although names of learned counsel have been shown in the cause list. Respondent is represented by learned counsel. On the previous date also, that is 19 to 26, none had appeared for the appellants, although respondents were represented by learned counsel, and names of learned counsel for the appellant were shown in the cause list on that day as well. Therefore, it appears that the appellants are not interested in pursuing the appeal. Consequently, the appeal stands dismissed for non-prosecution.
Much obliged, lordship.
You're Mr. Day.
My lord. May please your lordship. If the appellant is challenge the order of the learned RCD lordship. Judgment dated 10/5/2016. As by the learned Rail Claims Tribunal, Gauhati bench, Gauhati lordship. Lordship, the judgment page number 13, lordship.
Page
number 13. The claim petition.
Yes.
Lordship, I am reading the judgment, lordship. I am reading the judgment, lordship. This application is filed under section 16 of the Rail Claims Tribunal Act 1987 by the applicant for award of rupees so along with interest and cost on the account of damage rupees damage of 13,150 kg of potatoes during transit. It is averred by the applicant that the consignment of 850 bags of the potatoes of 50 kg packet each was booked on 15/9/2009 under invoice number so-and-so, railway receipt number so-and-so from DKZ to NGC under train load condition. This is very important, under train load condition. In safe, sound and secured condition under railway risk rate after meeting all legal and statutory inspection as per the railway rules. The wagons containing the consignment were stranded at KIUL for about a week. On being requested, CGS NGC issued a telegraphic message dated 25/9/2009 for immediate moving of the standard wagons to destination to avoid damage to the potatoes. The applicant further averred that the consignment reached destination after abnormal delay, and at the time of unloading, it found wagon's doors in open condition, wagon roof leaky, wagon body in damaged condition, and stacks of potatoes in wet, damaged, rotten condition, and foul smell was emitting from it. On unloading, it found 1315 kg of potatoes in wet, damaged, and rotten condition. After proper inspection and verification, respondent railway issued necessary short and damage certificates. It is also averred by the applicant that despite serving notice along with the original damage delivery certificate and copy of bijouks, the respondents did not pay any compensation. As the damage was due to negligence on the part of the respondent railway during railway transit, the respondent is liable to compensate the loss sustained by the applicant along with the interest and cost. My lord, this part is the applicant's grievance before the tribunal, lordship. And next part, lordship, para number 3, the railway has filed the written statement before the tribunal. Here 2-3 important points is there. The respondent filed written statement and additional written statement resisting the claim of the applicant. Therein, the respondent averted that the applicant is a juristic person. Here, this is the number 1 point. The applicant who claimed is a juristic person, which can only be represented by a natural person. However, the applicant has not disclosed the name of any natural person who would represent the applicant firm before the Honorable Tribunal. Hence, the application is not maintainable. It is also awarded that they not only deny the number of bags of potatoes claimed by the applicant to have been loaded, but also deny the claimed value of the potatoes. The applicant has no cause of action right to sue as the application is not verified by the proper person having authority. It further awarded that it denies the validity and sufficiency of notice under Section 106 of the Railway Act. The consignment reached destination in time. The so-called short certificate upon which the applicant had placed much reliance is in fact of certificate as to the factum of the condition and volume of goods at the time of delivery. Therefore, conclusion of shortage cannot be drawn unless the quantity of consignment entrusted to railway is proved. The copy of bijouks purported to have been issued by Nitin Traders as well as RS Traders are not trustworthy on the ground that it does not bear reflect and registration number of the firm, tax number, seal of the firm, and full signature of the authorized signatory. Very important part. The consignor has not complied with the statutory provision as required for packing of the consignment, and that the wagons were jointly examined and found fit and watertight as reflected in RR. RR means railway receipt and forwarding note. The consignment was booked by sender at forwarding station under remarks in the railway receipt. Wagon jointly examined, found fit and watertight. train load condition complied with, loaded direct from truck to wagon, loading not supervised by the railway staff. It is a very important part, Lordship. Bags not uniform size condition of contents not checked by the railway staff, set to content. This is the important part. The consignor booked their materials as a set to content. Set to content means, Lordship, the authority, railway authority will not check the bags and what amount of they loaded, nothing will be checked, because it is a they have given some relaxation of the price, freight price, and for that it is a set to content. Checking condition, outer not complied, or the respondent is not liable for the alleged damage as consignment was booked at owner's risk rate. It is a owner's risk rate, Lordship, not railway risk rate. In their applicant, they claim that while they book their consignment, it is a railway risk rate, but it is not correct, Lordship. Lordship will find it in the records itself, whether it is a owner's risk rate or railway risk rate. If it is a railway risk rate, then the case will be in their favor. If it is not a railway risk rate, then the case is in our favor, Lordship. Our contention is
It is, what is the owner's risk rate?
owner's risk rate. If the owner's risk rate, all burden goes to them only, that they have to prove how much quantity of the material they loaded in the train, Lordship. It is, they have to prove, because it is a owner's risk rate. So for the section 65, subsection 2 of the Railway Act 1989. And under the section 97 of the Railway Act, at the time of granting delivery, the consignor, consignee, endorsee was required to produce the sender's original trade invoice, but it did not produce any such documents. As such, the respondent did not have the opportunity to check or verify the consignment with the railway receipt. With these averments, the respondent prayed for dismissal of the claim application with cost. Now, the issue made by the learned tribunal, Lordship. On the basis of the pleadings of the parties, the following issues were framed for the determination. Was there been a proper notice under section 106 of the Railway Act? Number one. Number two, was there been any damage as contended by the applicant? Number three, whether the respondent is liable to pay compensation, if so, to what sum? Number four, reliefs and cost. But here, Lordship, all the issues in favor of the applicants. The learned tribunal passed the judgment, all the issues in favor of the, without considering the Railway Acts, Lordship. And in the railway receipt, it is specifically written that the consignor booked their potatoes in the owner's risk rate, and it is a set to content. Now, Lordship, the ground we have taken before this honorable court, ground number, my lord, page number 8, ground number 3, Lordship. For that, the learned tribunal, while passing the impugn order, has failed to take into consideration the remarks indicated in the railway receipt, that the consignment was booked by the sender at forwarding station with remarks wagon jointly examined. Now they are claiming that the wagons are leakage, so and so, so and so. But at the time of booking, they have jointly checked the wagon, all work, because train load means it is around 38 to 40 bogies lordship, wagons. So all checked by both railway and their consignor. Now at the destination, now they are telling that their allegation is the all wagons are leakage, doors are open, so and so, so and so. And not checked by the railway staff. Said to contain packing condition, outer not complaint in original receipt. And ground number 5, lordship, page number 9. For that, the learned tribunal has failed to consider the fact that the consignment was received and delivered from the original seal rabbit intact condition to the applicant. It's a very important part, lordship. While they have received, all wagons were in a intact seal condition. No door was open. Nothing. The original wagon holding the potatoes consignment arrived at the destination with original seal and rabbit intact condition without any criminal interference en route. The alleged shortage of the potatoes was due to the short loading by the sender at the forwarding station, for which railway is not responsible for any compensation claimed, etc. Number 6, ground number 6, lordship, the same page. For that, the learned tribunal, while passing the order, has failed to consider the fact that the copy of the Bijug purported to have been issued by Nitin traders as well as RS traders are not trustworthy on the ground that it does not reflect the registration number of the firm, tax number, seal of the firm, and full signature of the authorized signatory. Moreover, the learned tribunal has failed to take into consideration the following points. Number A, that the applicant has not loaded 850 bags of potatoes intact. There was short loading by the consignor at the forwarding station.
Before going through the grounds, let us first go through the impugned judgment. Then only we can evaluate whether the
Lordship.
grounds are correct or not.
Lordship. Now we remain the issues.
Yes.
Issue number 1, lordship.
Notice.
Issue number yes.
That is
That
proper.
is notice 106. The consignment was booked on 15/9/2009. Notice dated 12/10/2009 under section 106 of the Railway Acts 1989 was served by proprietor of the MS KC Enterprise, Gauhati, to the respondent, exhibited A5, receipt of which was acknowledged by the Chief Claim Officer NF Railway by his letter dated 16/10/2009, 20/10/2009, exhibited A8. Thereafter, the proprietor of the MS KC Enterprise served an amendment claim, letter dated 12/11/2009, to the respondent, which was also received by the officer of the respondent under clear seal and signature on 13/11/2009, Exhibit A9. Exhibit A5 and A9 bear all necessary particulars to understand the claim, article, dispatch, place of dispatch, destination, railway receipt number, etc. Perusal of reverse original railway receipt marked as Exhibit R2 shows that the consignee MS Nitin Traders endorsed the railway receipt in favor of MS KC Enterprise, Gauhati, that is the applicant herein, and delivery of goods were given to MS KC Enterprise. That shows that the applicant holds legal title to claim compensation. This is issue number 1, lordship.
Notice was served. That is the
As
finding.
per them, notice was served. Now issue number 2 to 4. These three issues are taken up together for discussion and decision for the sake of convenience. Exhibit A2 is an attested copy of message dated 25/9/2009 issued by CSGNGC to SS of /KIUL and other concerned railway officials, which states as under. As shown in FOIS/NHC, a rack of mixed goods consisting 42 BCNA. 42 BCNA means 42 wagon. X DKZ2 NGC and date of loading 15/9/2009 is standing since 19/9/2009 at yours. Please arrange to send this rack onwards to NGC at the earliest, as the rack containing 6 to 7 wagons stated by party perishable item potatoes to avoid damage of the consignment. The above clearly proves the claim of the applicant that the respondent has delivered the consignment at its destination after abnormal delay in transit, despite fully knowing the fact that consignment loaded was a perishable nature. That the fact that the consignment was delivered in damaged condition is confirmed by open assessment delivery report and copy of record of joint survey of open delivery report for shortage and damage, which were issued by the respondent railway and marked as exhibit A3 and A4. The delivery deficiency message issued by CS/G/NGC NF Railway exhibited R1 also confirms the above fact. Exhibit A3 and A4 shows quantum of damage as under. Damage in bags 189, actual damage in percentage 106 bags means 58% and 83 bags 70%. Weight of the one sound bags 50 kg. Actual damage in kg 3074 kg. Total 13109.05 kg. Total weight damage. Total weight
Alright, you
damage.
don't have to read that anyway. Come to 13.
Yes. 13. The Joint Traffic Commercial Claims Railway Boards DO letter number so-and-so dated 24/9/1991 states, it is seen that all the 7 places taken by the railway administration to repudiate claims on damage by weight are such as cannot be sustained in a court of law. Repudiation of claims on damage by weight on pleas such as said to contain. RR. Loading directly from truck to wagon or loading not supervised are relevant only in cases of shortage and not in case of damage by weight. Contention.
That is your contention. That is your document.
Lordship.
Then
It has been clearly
those are
indicated.
instructions from your own higher authority.
Lordship.
How can you deny that now?
No, that is I'm telling. That is my submission, Lordship. The shortage supervised are relevant. Loading directly from truck to wagon or loading not supervised. Clearly indicate to Journal Railway by letter number so and so. It is a railway instruction. It is our statement, Lordship. We stated that it is said to contain. They have directly loaded the wagon from truck to wagon. It is not supervised the railway authority because it is a said to contain. It is our statement. We are not denying, and this is our case. This is a case of said to contain.
And your letter says that those pleas are not tenable in case of wet.
Yes, because wagon, it is a wagon load, it is a train load condition. So train load condition, Lordship, what happened? Their contention, while they are train loading condition, they booked under concession rate. When it is concession rate, at that moment, railway staff will not supervise. And
your joint director traffic commercial letter says that the plea that you are taking, non-supervision, etc.,
Lordship.
those pleas are not acceptable in a court of law. That is your own statement.
So it is as per section 65, subsection 2 of the Railway Act, Lordship. It is not supervised because
Then what is the value of this?
That part will come, Lordship, and there is a Supreme Court judgment on the same section also, Lordship. While it is a set to content, Supreme Court also says that, yes, the authority will not concern. Whatever you have damaged, lost, the burden lies on the consignor only. They have to prove that they have loaded 850 bags of consignment.
But your own authority, claims authority says that it is not necessary in case of wet. This letter. This is binding on you or not, your authority's letter?
Sure.
Then
I'm reading, Lordship, again. Reputation of the claims on damage by weight on pleas such as set to content, RR, loading directly from track to wagon or loading not supervised are relevant only in case of shortage and not in case of damage by weight.
so this is a case of damage by wetting. Present case.
Yes.
So this is the pleas that you take, those are not acceptable. It is not a case of shortage.
No, this is not a case of shortage. This is a damage, Lordship.
By wet.
By weight. As well as shortage also, Lordship. Their claim in their claim petition, the shortage also there. Shortage also, no?
I don't think so.
Okay. Damage by weight during transit are payable unless it is proved by the railway that the goods were already in damaged condition at the time of booking.
And only 2,52,000.
No, actually, my lord, my respectful submission, amount is immaterial. Only thing is, Lordship, this will be precedent, Lordship. For that only, these authorities before this honorable court. Amount is immaterial, Lordship, whatever. Even rupees 75,000, for that also, that in that case also file the appeal, Lordship. Only because of that. And 14, Lordship. Rule 1418B and G of Indian Railway Commercial Manual Volume 2, 1991 read, when a consignment tendered for dispatch is not packed in accordance with the packing condition laid down in the IRCA goods, tariff or is insecurely fastened or packed or shows signs of pilferage or in the defective condition as a consequence of which is liable to deterioration, leakage, wastage or damage in transit. It should be ensured that remarks as to the exact defect in packing or nature of defective condition of the consignment in recorded on the forwarding note clearly and in detail by the consignor or his authorized agent in his own handwriting. The entire remarks regarding defective packing or the nature of defective condition of the consignment recorded on the forwarding note by the sender or his authorized agent should be copied out verbatim on all the foils of the connected invoice, including the railway receipt. The staff are not authorized to enter any remarks regarding defective packing, etc. on the invoice or railway receipt. If similar remarks have not been entered on the forwarding note by the sender or his authorized agent. Number 15, Lordship, it is held in the case of Union of India versus Laduram AIR 1974 Calcutta 207 that in order that the railway administration may be absolved of its liability under Section 73, it is necessary that the forwarding note not only there should be a recording about the defective or improper packing of the goods, but also it should be further recorded that as a result of such defective or improper packing, the goods are liable to damage, deterioration, leakage, or wastage. It would therefore be necessary to examine whether the fact of defective or improper packing and the consequence thereof in the instant cases has been recorded by the sender or his agent in the forwarding note. Perusal of the forwarding note exhibit R4 shows that no such adverse remark has been found recorded on it. The railway staff should have refused booking of such consignment if it were defectively or improper packed, since nobody prevent them to do so. It is not correct, Lordship. This contention of...
But it is not correct.
This
Can
was
you
correct.
dispute the contents of Exhibit 4, which shows that there was no adverse remark?
Yes.
Yes, sixth rule.
And 16 is
1512,
business rules, Lordship.
1529.
Yes. And rule 1529, 1512. Tally book for outward goods. While loading goods should be carefully tail into wagons, and description and number of packages of each consignment put into each wagon should be entered in the tally book from commercial T1 REV, which is supplied to every loading clerk to stand at the door of the wagon and record in his tally book in each package or articles that is passed into the wagon. It is improper that the entries are made directly in the tally book at the time the packages are loaded and not copied out from rough notebooks. Rule 1529. And then 1529. Loading and unloading of goods in assisted or provided sidings. A, whereas goods clerk is posted in an assisted private siding and his wages and other costs are paid for by the owner thereof. The loading of goods will be supervised and daily by the goods clerk, and railway receipt will be granted for the specific number of packages loaded. Similarly, unloading of inward goods will be supervised and tallied by him. See para 2513 also. Rule 1713. My lord, all these rules, it is...
All right, these are there. No dispute about that.
Yes, it is the rules. It is the rules. And in 17, Lordship, citation, probably, in the case of the
Let's
Union
go
of
to the
India-
finding 18.
Yes, number 18, Lordship. The respondent was directed by this tribunal to produce the documents sought for by the applicant in its prior for discovery of the documents, that is original forwarding note, loading tally book of booking station, original railway receipt, seals and card labels, unloading tally and delivery deficiency, message, and all records about the movement of the wagons during railway transit. Out of the above documents sought for by the applicant, the respondent only produced original railway receipt, copy of forwarding note, and delivery deficiency message of destination station. Number 19. Despite direction given by this tribunal, the respondent did not produce the loading tally, seal and card labels, transit reports, and unloading tally. In absence of this, it is not conclusively proved by the respondent that the damage of the consignment was not due to negligence on the part of the railways during transit and that the wagons were received in sealed, rabbit intact condition. Plea of the respondent that open cum assessment delivery report was issued without prejudice is not sustainable in view of settled legal position decided by Honorable Gauhati High Court in MFA 20 of 2008 on 27/11/2015 in the case of General Manager NF Railway versus MS Sunrise Trading, para 11 thereof read as follows.
So we have read the judgment.
Yes. MSB Devi Learned Counsel for the applicant would argue
That is certificate is binding on me.
Lordship. Lordship. Then number 20, Lordship. Considering the facts stated above, evidence available on record, and guided by the judgment cited supra, it is held that 13,109.05 kg of potatoes were delivered in damaged condition by the respondent to the applicant, and the respondent is held liable to compensate the loss suffered by the applicant with cost and interest. Number 21, as regards.
You can skip that part.
Okay,
Yes.
okay, that is a. And now lastly, it is the orders of this tribunal. So, my lord, kindly turn into page number 8, ground number 3.
8. Page number
8. Page number 8. For that, learned tribunal, while passing the impugned order, has failed to take into consideration the remarks indicated in the railway receipt that the consignment was booked by the sender at the forwarding station with remarks wagon jointly examined, found fit and watertight train load condition, complied with, loaded directly from truck/car to wagon, loading not supervised by the railway staff, bags not of uniform size, condition of content not checked by the railway staff, said to contain packaging condition, outer not complain, original receipt. Here, the wagons at the time of booking, both the parties jointly examine the wagons, Lordship. At that time, they found all wagons are fit. And ground number 4, Lordship. For that, the learned tribunal did not take into consideration of the fact that the so-called short certificate upon which the applicant had placed much reliance is in fact a certificate as to the factum of condition and volume of goods at the time of delivery. We cannot simply came to the conclusion of shortage unless we get the quantity of consignment entrusted to railway.
This is irrelevant.
Lordship,
Your whole memo of appeal, this is the most irrelevant ground. There was no finding of shortage. There was no claim of shortage. Claim was of damage. Tribunal never came to a finding of shortage.
yes. The last part of this, Lordship, in the instant case, the applicant has failed to bring on record any material to show or prove the quantity of consignment entrusted to the railway. As such, the shortage cannot be
Again on shortage.
determined. Shortage part is over. Moreover, the copy of purported visa issued by Nitin traders as well as RS traders are not trustworthy. Rather, the same are highly doubtful document on the following grounds.
You are
A,
making out a new story now. As if the wagons, as if the potatoes were never there.
all right, Lordship. Lordship is a para number 5. For that, the learned tribunal has failed to consider the fact that the consignment was received and delivered from the original seal rabbit intact condition to the applicant. The original wagon holding the potatoes consignment arrived at the destination with original seal rabbit intact condition without any criminal interference in en route. The alleged shortage of potatoes was due to short loading by the sender at the forwarding station, but here short part is not there.
I think it is copy
But
paste.
only thing is, Lordship.
Only thing is that this is a copy paste petition, it seems.
While they
From
have
a shortage case.
while they have received that is intact condition, seal rabbit intact condition.
That is negated by your own damage certificate that you issued.
For that, the learned tribunal, while passing 6, 7. Lordship, I am coming to the ground number 7, page number 10, Lordship. Very important. Owner's risk rate. It is the owner's risk rate.
Ground?
7. Page number 10.
Yes.
For that, the learned tribunal has failed to take into consideration the law that has been laid down as per the Railway Act 1989. The consignment was booked at owner's risk rate under section 65 within bracket 2 and 97 with the Railways Act. At the time of granting delivery, the consignor was required to produce the sender's original trade invoice, but it did not produce any such document. As such, the appellant respondent did not have the opportunity to check or verify the consignment with the railway receipt.
Is that factually correct? Anyway, go on. Respondent will respond to that.
Yes. Number 8, Lordship. For that, the learned tribunal, while passing the impugned order, did not consider the fact that the shortage, this part is not required, Lordship. Number 9, Lordship, set to content is very important. Number 9, same page. For that, the learned tribunal, while passing the impugned judgment, has failed to take into consideration the law point that the consignment was booked under the remarks RR means Lordship railway receipt. As per section 65 and 97 of the Railway Act 1918N, relate to set to content remarks on RR. In the RR, it is specifically written, it is a set to content. As well as set to content remarks on RR, as well as non-supervision of the loading by railway staff is that the burden of proof about number of bags, quantity, quality and quantity. And what quality they have booked, lordship? This is the question. At the time of while they are loading, whether it is a damage. Because the potato, my lord, the potato, if one potato is damaged, then whole potato will be damaged. In the bag, if one,
That plea can be taken in every case. That, suppose there are tons of potatoes,
No,
we cannot
no,
check
only-
every potato.
no, only
If
because
one potato is damaged, everything will be damaged.
that is true, lordship. It is only thing is, lordship, because their contention is they have booked the consignment on set to content. If they have not booked in set to content, then no question arises. Lordship. So if it is set to content, the railway authority will not check, not supervise. The question is now burden lies to them only as per section 9765 subsection 2 and 110 of the Railway Act, that they have to prove. Hello. Hello, here I am referring one Supreme Court judgment, lordship, regarding owner's risk rate and set to content. Probably, lordship is aware of the judgment. Horisha and other versus State of Bihar. There are number 6, 7, 8, and 9, lordship.
There are 6.
There are 6, 7, 8, and 9, lordship. My lord, I am reading para number 6, last part, page number 110. Last part, under section 74, where goods are tendered to a railway administration for carriage at a special reduced rate. This is set to contents means lot special reduced rate known as owner's risk rate. Then, notwithstanding anything contained in section 73, the railway administration is not to be responsible for any loss, destruction, damage, lordship. Damage part is covered, lordship. Damage, etc. from whatever causes arising, except upon proof that such loss, damage, destruction, etc. was due to negligence or misconduct on the part of the railway administration or any of its servant. Under section 106, a person requested under section 58 to give an account with respect to any goods and giving one which is materially false may be punished with fine which may extend to rupees 150 for every quantity or part of a quintal of the goods in addition to any rate or other charges to which the goods may be liable. My lord, here damage part is clearly specifically stated in the Supreme Court also here.
Question is about the proof part.
Lordship.
Yes. So when your own communication says that there is inordinate delay in consigning,
no, but
is there any separate?
No, Lordship.
Should the claimant
No,
leave any separate proof evidence?
Lordship, it is their contention, but we stated that no, we have not delayed.
No, your communication is quoted there in the impious judgment.
Because, my lord, it is a long route. The goods train coming, lots of problem maybe arises in during the en route, lordship.
There are
Maybe
different mechanisms for that.
May not be reach in time also, lordship. That is, and the question here is whether they have loaded the potatoes in a good condition. All bags, sir. So burden lies to them only, Lordship. So for this section 110 of the Railway Act and 65 of 2. And Lordship, para number 7, may I read it, Lordship? Para number 7, it is in the middle part, Lordship. Line number from 11, Lordship. I'm reading, Lordship. There can be little doubt that railway did not run any additional risks. In case the goods were consumed by fire or even stolen from the wagon due to any negligence on the part of the railway administration, the owner would have to prove that he had put on railway 251 bags of chilies. He would also have to prove the weight of the chilies and approximate value thereof. For this, he would have to call evidence to show how and when he acquired the goods and the prices he paid for them and exactly what quantity he loaded in the wagons. There would be no presumption that the goods put in the wagon were chilies because the railroad did not accept the consignment. As such, they described it as 251 bags alleged contained chilies. Nor was there any acceptance of the weight of the goods by the railway. The endorsement SWA would negative the plea if any that the weight was loading and unloading being in charge of consignor, the railroad could not be held liable for any negligence in loading or unloading. At the time of loading and unloading, railway is not liable at all, Lordship. And lastly, para number 9, Lordship. In Dominion of India versus Pritam Meza and Kinsella, a railway receipt was issued to a consignor qualified with the statement that the wagon was said to contain 255 bags of coconuts, as only 251 bags were received at the destination. The plaintiff made a claim for the price of the 4 bags of coconuts by way of damage. It was held by the Nagpur High Court that there was no proof that 255 bags had in fact been loaded. Referring to Rule 22 of the Goods Tariff General Rules, it was said that the receipt issued qualified the number by stating that
That is about shortage. What about quality?
shortage, damage, both are covered, Lordship, in this judgment, Lordship. Shortage as well as damage also, Lordship. So all the burden lies on the claimant itself, Lordship. The High Court judgment repeat. My lord, with the reference of this Supreme Court judgment, lots of judgments are already given by this Honorable Court, Lordship, in favor of this both shortage and damage. Lots of judgment is there. Gauhati High Court, Lordship. Reference of this Supreme Court judgment, Lordship.
All right. Yes.
Please, your lordship. This appeal is not maintainable, both factually as well as on
Yes. Let's go to the legal first.
lordship. In this case, lordship, this is a case of consignment where we have received the potato consignment in damaged condition, lordship. So there was a delay as it is admitted in their letter, lordship. That is the memo dated 20 in the judgment. It is recorded in the judgment that message dated 25/9/2009, Exhibit A2, lordship. This letter shows that the consignment was remained stranded since 19/9/2009 for 4 days, lordship. And then the concerned authority requested the person of that station to bring back this consignment to the destination station, lordship, because this is a consignment of perishable item. So, lordship, there was a delay. On that part, lordship, section 95 is very important. Section 95 says delays in transit. Section 95 of the Railways Act 1989. Section 95 says, a railway administration shall not be responsible for the loss, destruction, damage, or deterioration of any consignment proved by the owner to have been caused by the delay or detention in their carriage. If the railway administration proves that the delay or detention arose for reasons beyond its control or without negligence or misconduct on its part or on the part of any of its servants. In the present case, they have not given any such explanation why these consignments were stranded at the particular station, that is KIUL, lordship. And in this regard, lordship, there are a number of judgments of this honorable court discuss about section 95, lordship. That is in MFA 19 of 2012. As well as MFA 27 of 2012. MFA 19, paragraph 27. May I read from paragraph 27?
MFA 19.
MFA 19 of 2012. In this case also, lordship, this is a case of consignment where we have received 2731 bags of cement in damaged condition. And there was a delay of 70 days. So in paragraph 27, I'm reading from paragraph 27. It is seen that section 93, first lordship, section 93 is also very relevant, provides as follows: general responsibility of a railway administration as carriers of goods. Save as otherwise provided in this act, a railway administration shall be responsible for the loss, destruction, damage, or deterioration in transit or non-delivery of any consignment arising from any cause except the following, namely, F. Act or omission or negligence of the consignor or the consignee or the endorsee or the agent or servant of the consignor or the consignee or the endorsee. G. Natural deterioration or wastage in bulk or weight due to inherent defect, quality or vice of the goods, latent defects, provided that even where such loss, destruction, damage, deterioration, or non-delivery is proved to have arisen from any one or more of the aforesaid causes, the railway administration shall not be relieved of its responsibility for the loss, destruction, damage, deterioration, or non-delivery unless the railway administration further proves that it has used reasonable foresight and care in the carriage of goods. It is seen that there are copies of assessment delivery certificate for shortage and damage issued by the station superintendent North Lakhimpur Railway showing that it had received correctly 25,140 bags cement, of which 5745 bags were in damaged condition. However, there is no document to substantiate the claim that 1115 bags of cement of the suit consignment were received in damaged condition at the transshipment point. This court find that the learned tribunal had rightly observed that no explanation is forthcoming from the respondent railway as to how the consignment was dealt with at the transshipment when it was in their custody. Moreover, the argument that the initial loading of the consignment was defective is not substantiated, as the RR contains no adverse remarks regarding loading of the suit consignment by the consignor, and it was loaded at railway risk rate. Para 29. It was also seen that the railways have tried to explain that the reason for the delay explained was the cement was booked by the sender Messrs. Lafarge India Private Limited from Akaltara station to Silapathar station, transship at Rangia and intercepted at North Lakhimpur as per request of the consignee, owing to rail link between NLP and STPR being cut off for long time. The railway authority had followed the respondent to take delivery of the consignment at short of destination without realizing interception fees and also to refund the freight charge for the said untraveled portion. This court, however, finds that though the appellant NF Railways have submitted that it was fault of the consignor that the cement was not packed properly as per the requirement norms, it is seen that in the invoice number so-and-so shows the risk rate as RR, which can only be construed as railway risk. Further, there is no document to substantiate the claim that from the transshipment particulars it has transpired that all bags were received correctly, of which 11-15 bags were found stony condition from SRI wagon. There is also no document to substantiate the claim that the book was done under Section 65 of the Railways Act and therefore at the owner's risk. There is no receipt produced which shows that the endorsement said to contain in the booking of the cement bags. In the documents available on record, it is seen that the respondent had issued letters dated so-and-so regarding the non-delivery of goods, and thereafter the goods had arrived on 16/10/2009 and 18/10/2009 after a delay of 70 days. There was no explanation or evidence produced by the appellant to show that due to inherent vice of the commodity and packing conditions which were not complied with, the railway were not liable, since the railway receipt at the time of packing of the consignment had no adverse remarks. If the consignment had inherent defect of loading or arrangement of proper dunnage, the railway receipt must bear the impression. In this regard, the respondent cited Rule 1418BG of the Indian Railway Commercial Manual of 1991, which laid down the rule for examination of packing of goods, etc. Further, Section 110 of A of the Railways Act does not require the person claiming compensation to prove how the loss, destruction, damage, deterioration, or non-delivery was caused. In the instant case, the value of the damaged goods as agreed by both the parties is taken to be so-and-so. So, Lordship, here there was a delay of 70 days and the railway administration did not explain how the delay was occurred, Lordship. And Lordship, in as per Section 110, the burden of proving the burden of proof, Lordship, is upon the consignor or consignee only with respect to proving.
110.
Yes, Lordship. 110A of the Railways Act 1989 is only upon the consignor and consignee to prove the monetary loss actually sustained for, Lordship. In the present case, we have produced the invoice, Lordship, issued by the consignee Nitin Traders. And Lordship, we are the endorsee in the present case. The consignee made the endorsement in favor of the claimant, Lordship, and accordingly, in the capacity of endorsee, we preferred this claim application. So, Lordship, as per Section 110A, the burden of proving the compensation for claiming the compensation is only with respect to the monetary loss that we have actually suffered, Lordship. So 110A is relevant. And so far as Section 65 is concerned, Lordship, this is not a case of shortage of the consignment, Lordship. And Lordship, if there is any adverse remark with regard to the quality of the commodities, Lordship, that will be reflected in the forwarding note. And Lordship, the forwarding note is there in the TCR, Lordship. I have checked the report and there is no such adverse remark with regard to the quality of the goods, the potatoes, Lordship. And Lordship, as per IRCM Rule 1418B and G, Lordship, if there is any adverse remark, that will be written by the consignor in his own handwriting, Lordship. So these parts were need to be considered, Lordship, and the learned tribunal had rightly decided this matter in favor of the claimant, Lordship. More so, Lordship, Section 93 may kindly see Lordship, section 93 of the Railways Act 1989. Here, even though Lordship, there are 9 exceptions, but Railway shall not be relieved its responsibility to prove that they have taken extra care for the laws, for the commodities, Lordship, during transit. So proviso to section 93 is also very relevant in this case. Now, Lordship, they are saying that the burden of proving the consignment that is upon the consigner, Lordship. Here, as per section 110, we have proved our burden, Lordship, by producing the invoice. Now, Lordship, another judgment I would like to place before your Lordship is of the Honorable Supreme Court in Civil Appeal number 1237 of 1968.
What is this, the material on the basis of which it is contended by the appellant that the booking was done at owner's risk on under section 65 of the Act?
Lordship, in the railway receipt, there is a remark, owner's receipt. Railway receipt is there, Lordship, in the TCR. Even though the consignment was booked under owner's risk rate, but this is a case where we have received the consignment in damaged condition. So 7 pleas were not available with them as per their own letter, Lordship. It is very well recorded in the judgment itself, Lordship. So they cannot deny that these pleas were maintainable in case of the consignment received in damaged condition, Lordship. And the Lordship, I have placed one judgment of this of the Honorable Supreme Court, Lordship. May kindly see that judgment. This judgment is also very relevant with respect to section 95 of the Railways Act, Lordship. That is delay in transit, Lordship. Para 9.
Just a moment. No, what is your submission with regard to that? The railway receipt shows that it was booked at owner's risk rate. And according to what is submitted on behalf of the appellant,
Lordship, as per section 65, Lordship,
you have to prove the quality then
the
at the time of booking.
Lordship, as per section 64, we have executed one document that is called forwarding note. That document is very relevant, Lordship. In that document, Lordship, we will going to at the time of booking of the consignment, we will record the quality of the and nature of the product, Lordship, quantity of the materials, Lordship, and as well as the packing condition. These remarks has to be there in the forwarding note. And I have checked the forwarding note. There is no such remark noted by the consigner in their writing, Lordship. And as per rule 1418G, if there is any adverse remark, then liability is upon the person to prove that they have not loaded the damaged goods, Lordship. Now, there is no dispute in receiving the number of books that are actually loaded at the time of booking, Lordship. There is a dispute of receiving the goods in damaged condition. And Lordship, as per Section 83 of the Railways Act 1989, open cum assessment delivery proceeding was exercised, Lordship, in terms of Section 83. And as per that report, Lordship, they have admitted that the wagon was found in leaky condition in that report, Lordship. And Lordship, the burden of proving the case, Lordship, is upon the person only with respect to Section 110, Lordship. Section 110 says, in an application before the claims tribunal for compensation for loss, destruction, damage, deterioration, or non-delivery of any goods, the burden of proving A, the monetary loss actually sustained, or B, where the value has been declared under subsection 2 of section 103 in respect of any consignment that the value so declared is its true value, shall lie on the person claiming compensation, but subject to the other provisions contained in this act, it shall not be necessary for him to prove how the loss, destruction, damage, deterioration, or non-delivery was caused. Our duty is to prove the monetary loss that we have already, Lordship, discharged our duty by producing the invoice, Lordship. And in that invoice, Lordship, their license number is also there. They are disputed that no license number, no GST number is mentioned in that invoice, Lordship. But this is a wrong statement. In the said invoices, Lordship, I have checked that their license number is there, Lordship. So it is a genuine document, and they have filed the original invoice, Lordship, before the tribunal. And on the basis of that invoice, Lordship, compensation was granted, Lordship. So our burden of proof to prove that we have actually sustained that type of that much of monetary loss, Lordship, we have already proved it, Lordship. And so far as owner's risk is concerned, Lordship, since this is a consignment of perishable in nature, Lordship, so perishable items were again already booked in owner's risk rate, Lordship. So for owner's risk rate, their duty is to deliver the consignment within the prescribed time, Lordship. So normal transit time is 10 days, Lordship, and they have taken almost 14 days. So for within a gap of 4 days, Lordship, the consignment got deteriorated, Lordship. So this is my case, Lordship. They have not explained the delay, and I have already furnished one judgment of this Honorable Supreme Court, para 9. So far as delay is concerned, Lordship, the Honorable Court clearly says that, Lordship, para 9, Lordship.
Para 9, no? Which one?
Union of India versus the Steel Stockholders Syndicate Pune, decided on 1/3/1976. Para 9, Lordship.
Yes.
The first contention put forward by the Solicitor General was that the case of the plaintiff does not fall under any contingencies contemplated by Section 76 of the new Act. Section 76 runs thus. This Section 76 is now Section 75, Lordship. A railway administration shall be responsible for loss, destruction, damage, or deterioration of animals or goods proved by the owner to have been caused by delay or detention in their carriage, unless the railway administration proves that the delay or detention arose without negligence or misconduct on the part of the railway administration or of any of its servants. It is submitted that although there was delay in the delivery of the goods on the part of the railway administration, but the railway administration would be responsible only if the plaintiff further proves that there has been loss, destruction, damage, or deterioration of the goods by virtue of the delay. It is true that the plaintiff has not alleged that there was any physical loss, destruction, damage, or deterioration of the goods, but that, in our opinion, does not put the plaintiff out of court. Section 76 appears to have a very limited scope. It contemplates clearly those cases which fall within the contingencies contemplated by Section 76. These contingencies refer to certain physical factors with actual and physical loss, destruction, damage, or deterioration of goods. For instance, where the goods worth rupees 10,000 due to delayed delivery have sustained deterioration, as a result of which their value has gone down to rupees 5,000. Then once this fact is proved, the railway administration shall be liable for such a loss or the value of such deterioration. We are of the opinion that Section 73 of the new Act, while converting the liability of the railway administration from that of a carrier to that of an insurer, has imposed heavier responsibility on the railway administration. Now, Lordship, as per assessment, open cum assessment delivery report, Lordship, the damage is assessed, Lordship. Lordship, may kindly turn to page 6, internal page 6 of the impugned judgment, Lordship. In paragraph 12, the report of the open cum assessment delivery report was extracted in the judgment, Lordship, and the actual damage was assessed. And Lordship, total wet damage of the consignment comes to 13,109 kg, Lordship. So this damage was page paragraph 12 of the judgment, Lordship. So the railway have assessed this damage, Lordship, and the report was prepared where, Lordship, it was recorded that out of 189 damage books, actual damage in percentage is 58% and 70%. Again, in 376 bags, 256 bags, 40% actual damage was assessed, and in 120 bags, 45% was assessed, Lordship. So total comes to 13,109.5 kg. So this damage was recorded in terms of the open cum assessment delivery report issued by the railway, Lordship. This operation was conducted in terms of section 83. So as per this judgment, Lordship, if there is loss, then the railway administration is responsible to pay compensation. Now, by perusing this document, Lordship, damage was clear, Lordship. So we have suffered loss in respect to 13,109 kg of goods, Lordship. So my humble submission is, Lordship, this judgment of this Honorable Court is squarely covered, Lordship, because there was a delay which was never explained at the time of Lordship hearing, Lordship, before the learned tribunal. And in their message dated 25/9/2009, they have admitted that the consignment was standing since 19/9/2009, Lordship. Goods were loaded on 15/9/2009. So from 15 to 19, 4 days were remained stranded at the station, Lordship. They did not give any explanation why the consignments were stranded at that station, Lordship. So it is my humble submission that we are guided by section 95 as well as section 110A. Our duty is to prove the monetary loss, Lordship, that we have already discharged by proving the and producing the invoice, Lordship. And the invoice, Lordship, in the record, Lordship will find at page 49 and 50. Invoice is there, as well as forwarding note is at page, Lordship.
Page 49.
49 and 50
Of
of the TCR, Lordship.
TCR.
Is the forwarding note?
Forwarding note is at page.
You refer to 49 and 50. What's that? Page.
Two documents is invoices, huh? Like invoice issued by Nitin Traders. He is the consignee, Lordship. And Nitin Traders endorsed this consignment to Messrs. KC Enterprise, who is the respondent, Lordship, now. And on the next page, Lordship, RS Trader. So Nitin Traders purchased this material from RS Traders, Lordship. This invoice is also annexed with the claim application. Again, Lordship, I have also flag marked the open cum assessment delivery report. This report, here the damage was assessed, Lordship. And on the next page, there is a forwarding note, Lordship. And in the forwarding note, Lordship, front side will be filled by the consigner. And there is no adverse remark with regard to quality and condition of the goods, Lordship. And this forwarding note is executed under section 64 of the Railways Act. So on the basis of the forwarding note, railway receipt will be prepared by the Railways, Lordship. So if there is any remark, then that remark will have to be recorded in the railway receipt. So in absence of any such remarks, Lordship, we cannot presume that like the goods were booked under said to contain. Because the front side will be always filled by the consigner in his own writing, Lordship. And on the back side of this report, Lordship, this will be filled by the railway staff of the booking station. So whatever we have booked, they will copy that, and on the next page, they fill this column, and on the basis of this report, they prepared the railway receipt. So in the front side, there is no such remark with regard to said to contain, Lordship. Though the goods were booked under owner's risk rate, because it is a consignment of perishable in nature, Lordship. But Lordship, there is no such remark of said to contain. But on the back side, they put a remark, the rubber stamp. I don't know from where they get this authority to put that rubber stamp, Lordship. But this was not assigned by us, Lordship. And on the basis of this report, RR was prepared. RR we have filed, Lordship, with the claim application at page number 41. Said to contain plea will be applicable only in cases of where shortage is there, Lordship. Not a case where the consignee received the consignment in short numbers, Lordship. They have received the consignment in damaged condition. So as per their own letter dated 25/1/1991, Lordship, these 7 pleas were not applicable in the case of consignment received in damaged condition, Lordship. Now they cannot deny this letter at the appellate stage, Lordship. In the written statement, they did not review that document also, Lordship. That letter with 1977 letter, Lordship. 91, sorry. And one more submission, Lordship. So far as Supreme Court judgment passed in Harissa, Lordship, that judgment is not applicable. In that judgment, Lordship, the appellants were committed an offense under section 420 of the Indian Penal Code, Lordship. That was a case of cheating, Lordship. So that order is not maintainable and applicable in the present case, Lordship. The facts of the case is totally different, Lordship.
Yes. Anything else?
My learned friend rightly submitted before this honorable court that in the record, in the receipt, it is clearly specifically written the owner's risk rate. That is sufficient. That case is the trial court has wrongly decided. Owner's risk rate means all burden lies on the consignor. This is my humble submission before you, Lordship, and it is specifically stated in the section 97, Lordship, already my learned friend read out section 97 of the Railway Acts and 110 of the Railway Acts and 65 subsect of within bracket 2 of the Railway Act, section 65. All this covers the burden lies on the consignor that they have to prove that it is a damage. So far the Railway Act is concerned, and Supreme Court judgment what my learned friend submitted that is not reliable with the case, it is absolutely not correct, Lordship. The judgment specifically it is stated that said to contain an owner's risks. The owner's risks, the consignor has a responsibility to prove this. And it is a concession date, Lordship. Railway has given them a concession date. That is why it is a in the railway receipt it is written as it is a said to contain an owner's risk rate. Owner's risk rate means, Lordship, it is a said to contain. If there is a owner's risk rate, it is a said to contain. If it is not owner's risk rate, no said to contain. In the Supreme Court, it is clearly specified, Lordship.
Lordship, there is a specific provision for owner's risk rate, Lordship, in section 97, Lordship. Goods carried at owner's risk rate.
Yes.
There is a specific provision, Lordship. And nowhere it is mentioned that if the consignment booked under owner's risk rate, then it can be presumed that this is a consignment booked under said to contain remark, Lordship.
No, it is in the Supreme Court judgment, it is specifically stated, Lordship.
But their letter itself says that when there is a case of damage, Lordship, 7 pleas were not applicable, Lordship. And these pleas were never raised at the time of
Lordship,
filing of the written statement, Lordship.
one thing, Lordship, they stated it is a delay. In case of abnormal delay, Lordship, it is stated in the section 93, General Responsibility of the Railway Administration Credit Book, delay. If it is an abnormal delay, it is only 4 days. 4 days is not an abnormal delay, Lordship. It is a long way to come, Lordship. It is a whole train. It is not a wagon. They have booked train. Whole train it is coming, Lordship. 4 days. Goods train generally, Lordship, it is everybody knows lots of problem is there in the en route, Lordship. So it is not absolutely correct. The delay is caused. 4 days is not an abnormal, Lordship. In case of abnormal delay, Lordship, 4 days delay, it is written in the 4 days delay.
Section 95 may kindly see, Lordship.
Yes.
Lordship need to read section 95, Lordship.
I think we have done it once. 93 and 95.
93, 95, 110.
Yes. Noted.
And 97 also, Lordship.
97 is for owner's risk rate, Lordship.
Yes, this is owner's risk rate. This case is a owner's risk rate. It is in the RR, it is specifically written owner's risk rate.
Their own report says that the consignment was arrived in damaged conditions, so they cannot deny that.
That part is different.
Open come delivery report.
That is different, Lordship.
So our burden is to prove that how the damage is caused. That aspect is not there in section 110, Lordship. Our duty is to prove the monetary loss, Lordship, that we have already discharged by producing the invoices, Lordship. This is my humble submission, Lordship.
And 65 within bracket 2, Lordship, section 65 also.
Hello, it.
Obliged.
Obliged, Lordship.
So Lordship, today we have some difficulty. Upon 10th, Lordship, if it is not.
Old matter, my lord. It may be fixed, my lord, on 10th.
All right, as prayed for by learned counsel for both sides.
No, I have not prayed for you. I have no, I'm the appellant.
Just now you said let it be fixed on
No,
10th.
my lord, because
Then?
since he said, my lord, he has got some difficulty. I'm ready otherwise, my lord.
We are only talking about the date.
My lord, but I'm not seeking adjournment, my lord. That's my lord. Sorry, my lord.
Learned counsel for the appellant. Learned counsel for the respondent prays for adjournment for a short period. List the matter again on 10.
Much okay.
কিন্তু কি আহিব নাছিল আৰু 13 টো Yes.
Other side is not there, my insurance company.
Learned counsel for the appellant is present. Respondent insurance company. None appears for respondent insurance company. Let's have it on another date.
No, my lord.
List the matter again on.
My lord, at the prayer, my lord, supplementary list 23, my lord. Can it be taken up? My lord, he has come, my lord. Oh, your lordship has passed the order.
All right, we have passed the order now.
And 23, my lord, supplementary list.
Yes.
Next, next day, my lord.
Yes, give that date.
23? इधर पास में। इधर बस ना? इधर पास। ये तो date दिख गया प्रकार में ना। What? 17 March. What the item? What?
Call out item 19 since they need an upgradation. Yes, not in 19. Both sides are there.
An appeal against an order of temporary injunction.
And I am appealing for the appellant.
I am for the respondent.
My lord, may I give the background? My lord, we are presently, my lord, lordship, last order which was passed by this court. My lord, was January 28, 2026. May I just give a brief background of the matter? As this is coming before this honorable court for the first time. My lord, there was a civil suit which was filed in the year 2012. The plaintiff in the suit is that was the original plaintiff in the suit. Now he's dead. The plaintiff in the suit was late Hemant Prasad Barua. And that he had filed a suit in 2012 in respect of a chunk of share 8,61,918 share, which belongs to the plaintiff. Now, the plaintiff was at that time of time when he had filed the suit, he was about 86 years old. And few years before the suit was filed, the only son of the plaintiff had died. And under those circumstances, and according to the plaintiff, when he was alive here during his lifetime, because of operational conveniences, he allowed and he had requested that his daughter, who was then in India, his daughter, who is the opposite party number 2, Sharmila Shetty, should be made the second named holder in respect of the said shares. So those chunk of shares were 861,918 shares. So he said that he made a request before the bank, which was the HDFC Bank, the opposite party number 3 bank, that allow her name to be as a second name holder in the said, that the shares are dematerialized shares. They are not physical shares. They were kept in the demat account, in short we known as a demat account. And these shares were allowed to be kept in the dematerialized account. So the first name holder was the plaintiff, the father, and the second name holder became the one of the daughter, who is the opposite party number 2. Now, after some time, the plaintiff felt that he wanted to reorganize his business assets and shares. He has a business, he was a businessman. So he requested his daughter, who is opposite party number 2, that kindly, I'm sending you the delivery instruction. These were dematerialized shares, so they have to be transferred. Just like we sign the checkbook, there is a demat slip for transferring of shares. So he made the request to his daughter, I'm sending you the delivery instruction slips. You please sign those, and so that the shares come back to my account alone. I want to reorganize my business and assets, and I want to give this shares under a will. He wanted to bequeath the shares because he was already 86, but his daughter, who is opposite party number 2, refused. And there were correspondence exchange. The daughter refused. She said, I will not sign. So this state of affairs continued. So the father, during his lifetime in 2012, was compelled to file the suit before the Learned Civil Court, Gauhati, which is titled suit number 41 of 2012. In the suit, I will show you the players in the suit. I'm just giving a brief background now. In the suit, my lord, it was the contention of the plaintiff that he is the only person, he has sought a decree for declaration that he is the only person entitled to and the sole owner of the shares. And that entire consideration, according to the plaintiff, the father, was also paid by him. The daughter had not contributed a single naya paisa for buying or for subscribing in those shares. It was just that the father allowed the daughter to join for some period of time as the second name holder. Now, in the suit, one of the most important prayer is a declaration that the plaintiff is the owner and the sole owner of the shares. Now, because of the refusal on the part of the daughter to cooperate with his father and refuse to sign the delivery instruction slips, that this suit was filed. And in the suit, my lord, this suit was filed in the year 2012. In the suit, my lord, initially an interim order was passed on August 13, 2012, that there will be status quo maintained in respect of the subject matter of the suit, which are the shares in question. And this interim order continued, my lord, for some period of time. And thereafter, there was a further order. Then, after the suit was filed in the month of August 2012, the original plaintiff, Hemendra Prasad Barua, died on 31st July 2013. After his death, 10 days or 11 days after his death, the executor of his will, who is now the appellant and the petitioner before your lordship, Mr. Somnath Chatterjee, he filed an application for substitution. That now that the plaintiff has died, and as the executor, and lordship knows under the provisions of the Indian Succession Act, even before the probate is granted, that it is a duty of the executor to take all steps possible to collate the assets, to represent the person who has died, who is the testator, and to protect and safeguard the assets and properties which could form the part of the estate of the person who has died. So he filed the substitution application to be substituted in place of the deceased original plaintiff. Now, in this substitution application, an order was passed on December 23, 2013. And the learned court below had passed an order saying that till the probate is granted. In the meantime, the probate petition was also filed by the executor because here most of the assets and the was in Calcutta, the probate petition was filed before the Honorable High Court at Calcutta, which is pending. So the learned court below, the learned civil court, Jarat passed an order on 23rd December 2013 that till the probate is granted by the Honorable High Court, the substitution application will be kept in abeyance and as well as the suit will be kept in abeyance. This order was passed by the learned civil court, Jorat. From this order, my lord, both the executor, who is the petitioner before this honorable court, and the opposite party number 2, the daughter, filed their respective civil revision petition before this honorable court. Both of them filed. Both the civil revision petitions were taken up together and were dismissed by the common order on November 13, 2014. And the this honorable court confirmed the order passed by the learned civil court. From this order, none of the parties preferred a special petition. This state of affairs continued from 2014. Now, probate petition is pending. Now, in the probate petition, there is two important things. I will show the will also. Under the will, the executor is not the beneficiary. Executor is not a beneficiary. He's not getting a single naya paisa. He's not getting any asset. He's not getting a single share. Number one. Number two, all the other legal heirs, there was one, apart from the opposite party number 2, there was another daughter of the testator who has subsequently died also very recently. At that point of time, all the other legal heirs of the testator, the original deceased original plaintiff, have given the no objection to the grant of the probate. There is no opposition, including the daughter-in-law of the predeceased son also. As I told, his only son, Amit, died in 2008. So all the legal heirs of the testator gave the no objection affidavits, and the executor has annexed all those no objection affidavit in the probate petition filed before the High Court at Calcutta. The only person who objected was the opposite party number 2, the daughter, who after marriage is now a permanent resident of United States of America. Now, under the will, I will show there are many clauses where the lordship will find when I show the plaint also, the plaint and the will mentions during the plaintiff, the father in the will and in the plaint has specifically mentioned clauses of the reasons for keeping his daughter, who is opposite party number 2, out of his estate, his assets and properties. And in other sense, he has gone to the extent of even using the word disowning the daughter. So even if he uses the word disowning or disowning is not relevant because he has already indicated in the will the direction where his assets properties will go after his death. Now, this chunk of shares, which are the subject matter of the present suit, has been bequeathed to a trust, family trust comprising of the other family members of the testator. These shares have been bequeathed to a family trust known as the H. Heman Barua Benevolent and Family Trust. The petitioner, who is the executor, is not the beneficiary under the will. He is not the beneficiary or not even mentioned in the trust. He is not getting any shares from the trust also. He is not, his only job is, his only function is to discharge his duty as an executor. And after the probate is granted, to ensure that he takes steps to distribute the assets and properties so in terms of the will which has been, if the High Court at Calcutta grants the probate of the will ultimately. Now, probate petition is pending, where the only person objecting, as I told, is the daughter, who has filed an affidavit in support of her caveat. And in as per the procedure of our High Court, I am also coming from Calcutta. Once the affidavit in support of caveat is filed, the converted into a written statement, and the probate proceedings takes the character of a contentious cause and is now proceeds as an ordinary civil suit. That proceeding is pending. I will show how they are trying to delay that proceedings also. Now, in the meantime, what happened, Malad, in 2020, when immediately after the COVID, I'm so sorry, I think Mr. Chaudhary.
This is an appeal filed by the order. Order was there. Some proceedings have been this and they will. Lordship will fix it. Sometimes it is fixed.
After Holi, my lord, if your lordship so commences on 12th of March, my lord, we are coming from Calcutta. I have also a senior who is leading me. He is presently gone to the Honorable Apex Court here to move a specially petition. So, my lord, he was not able to come today. If my lord, if Mr. Martindar, if it's 12th of March, my lord, we can come back.
For the contesting, my learned friend is supporting the appellant. And my submission is, there is already an order passed by the Honorable Supreme Court to hear the matter at the earliest.
Yeah, we are all.
Today, my lord, all of us here.
Our request only it was passed.
That order was passed at our
Request only.
My lord, appeal is
My
today.
lord, Mr. Banerjee, who is leading me,
My lord,
so he's joined on the virtual mode. My lord. You
My lord,
want-
I'm extremely sorry, my lord. Today, my lord, I had to join on the virtual mode. I was supposed to be there, my lord. I'd been called away, my lord, to the matter, my lord, before the Honorable Supreme Court. That's why to come away. My lord, I'm making a request, my lord, if 12th of March, if it's possible, my lord, I shall be there, my lord, to argue it physically. I've always been attending the matter, my lord. I've been arguing.
Physically, come on, miss.
Physically.
My lord, today's date was fixed at their instance.
No.
Today the matter has
No,
come
no,
up.
at your instance.
We
at
had
your
said we will not convene. Mr. Mazumdar had insisted on this date.
My lord, I only said.
We had not agreed to this date, but because of Mr. Mazumdar's.
It's our appeal, my lord, so we will.
My lord, today the matter.
It's not my learned friend's appeal, Miller.
But we are affected. There is an interim order passed,
Yes,
so
yes,
there is an urgency in the matter.
Shying away.
Which has been accepted by the Honorable Supreme Court.
In this proceeding, there is an IA, my lord, and in the IA order has been passed.
In fact, there is a violation petition of which I am not pressing you.
Well, violation has got nothing to do with the appeal. my lord.
No, violation has something to do. Kindly allow us to
So far
come
as
back on
appeal is
12th of
concerned, my
March.
lord, appeal needs to be heard at the earliest. That's my suggestion.
Shying away.
We will.
So 12th is early enough for you, Mr. Mazumdar?
After the whole brief. Yeah.
12th of March.
Let's have Mr. Mazumdar's view
Well,
availability.
Yes, my lord. All
12th of March.
As agreed to by learned counsel for the parties, list the matter again on 12th of March.
Can it be on 13th? My learned friends, something else on there.
Friday को लेते नहीं हैं, Thursday रखना. 12th.
Take some time.
12th, मतलब we are coming from Calcutta. मतलब if 12th is it better. if
Next
Mr.
Tuesday, then if
Mazumdar-
it's a you have difficulty on 12th. Next Tuesday, the Tuesday after that.
12th March.
17th.
Then
12th. 12th we can start at least.
It will not be.
It will not be finished in one day.
Yes.
Since there is a direction, since there is a direction already.
oh yes, let them start on.
So it will not finish in one.
My lord.
Grateful, my lord, grateful.
Can the interim order passed earlier may continue?
Now, there is something else in my mind.
Yes, please.
If it has to continue beyond 12, depends on my availability.
Yes, sure, obviously. That is the first thing, my lord.
Because present roster is only up till 13th.
Can it be on
It
5th?
can
Then
change
5th is
on the next
hearing
date.
date.
And sir, Holi we have
So
59%.
I expect, since another roster will be coming out commencing from 15th. We cannot say as of now whether.
Then, my lord,
Not.
12th, my lord,
It
can
is
keep it.
better
my
we
lord,
fix it after 15th, whoever it is.
17th,
There will be continuity.
17th Holi.
17th.
Yes.
You're agreeable to that? Because that will again take away the urgency of the matter.
All right, 12th.
All right.
Grateful.
Lordship may kindly mention that the endeavor shall be made to dispose
Yes,
thereafter on that date.
Yes.
Yeah.
We
always before.
Let it be
And it
observed.
shall be made to
That
dispose
is.
of.
And then my mother, the interim order passed earlier may continue.
Yes.
Kindly.
Interim order
passed
first
earlier
and
may
it will
continue.
continue.
Right.
Grateful.
But to dispose of orders, we see it happening for 10 years at a on the go.
Extremely grateful.
All right.
Grateful.
Please, your lordship. Your lordship, matter may pass over for the day. The conducting officer, Mr. SP Roy, won't be able to attend
The
the.
prayer of learned counsel for the appellant, petitioner. Is the matter again on? Give a date.
Mr. Holy, your lordship. Yes, Your Lordship.
Yes, Lordship.
Yes.
Please, Your Lordship. Please, Your Lordship. In this case, the judgment was passed ex parte against the appellant, in spite of the fact that no notice was ever sent to the appellant in the proper address, correct address. Notice was sent to an address where insurance company never had any office.
Where did that address arise from?
Lordship, I can only suggest that probably arose from the fact that it's the address of the owner of the vehicle. It appears Lordship may see from the claim petition.
Now everybody has been served. All are appearing.
Lordship, the owner of the vehicle is an all India organization. They have an office in Gauhati, like we have made a paper publication, Lordship.
You are appearing for?
I am for a claimant, my lord. Claimant is
Claimant.
It is the matter fact that the case is of 2011. 11 husband died, wife filed a claim in the 2013, my lord. And the claim was disposed on 2018 by awarding amount of rupees 90 lakh something, my lord. In the before the trial court, the respondent insurance company did not appear, my lord. Did not appear, and thereafter the case was heard and disposed by giving award of rupees 19,000. It is in award was passed in 2018, my lord. And 2023, my lord, they have filed a petition that the order under Rule 13 was setting aside the expiry order on the ground that they have not received notice after 7 years, my lord. When after 7 years notice was passed, petition was filed, no petition for condonation of delay was filed. Only ground is that we came to know about the award only on today. I will read out the order.
No, how did they come to know only on that day? Because 7 years, if the award has been passed 7 years ago,
yes, my lord.
did you not approach the company for satisfaction of the
We
award?
could have gone for execution, also did not go for execution.
Your lordship, kindly see the order that at 26 2023 passed in the IA application, my lord, for the appeal, my lord. The next, the order passed in, my lord, this case number 03/2023
By the tribunal?
Rule 13, my lord.
By the tribunal?
Yeah, it is the order, my lord. I may be allowed to read out.
Yes,
this.
yes.
The petitioner insurer is the unrepresented. Then on the date of the hearing of the petition, under ordinary rule 13, that did not appear. In the original suit, claim that did not appear, my lord. Unrepresented. The claimant is represented by the engaged counsel. I have perused the petition number 440 of 2023, filed by opposite insurance company under ordinary rule 13 of CPC for setting aside the expiry judgment dated 9/4/2018, my lord. It is in 2023 they have filed the petition. I have also perused the objection filed by the claimant side and heard the side. On perusal of the case record, it is found that the said ex parte judgment was passed on 9/4/2018, and it was directed that the copy of the judgment and order be communicated to the opposite party, but thereafter the opposite insurance company filed a petition on 17/2/2023, thereafter 7 years, 23, stating that only on 1/2/2023, the OP insurance company came to know about the said judgment. How they know, it is not stated. Judgment without mentioning any further details regarding the manner and the source of their knowledge. On the other hand, from the judgment dated Iman, it is found that it was mentioned therein that the opposite party did not appear to contest the case in spite of the receipt of notice. It may be mentioned here that the burden is upon the OP insurance company to establish that that it came to have knowledge about this about the decree on 1/2/2023 and thereafter filed the application on 17/2/2023 to set aside the same, but the opposite party insurance company failed to discharge its burden in this regard and merely quoted the date of knowledge, asking into consideration or taking into considerations all these facts and circumstances. I am of the opinion that the OP's insurance company could not justify the long absence of delay or it is the part of thereof. I decline to give any relief to the petitioner. Insurance company is at stage, and accordingly, the said petition 440/783 stand rejected. The opposite party insurance company is directed to pay the awarded amount with interest of the claimant within 45 days. So even in this way, they have not filed any petition for condonation of delay under order filed, or how they came to know about this decree after 7/8. That is also not stated. They did not appear on the date of hearing in both the cases, my lord. So the trial court has rightly rejected this petition and rightly passed that award, my lord. The award is, his award is also not so, not so high, because he is a 4th-grade employee getting in a salary of 12,000 something, and multiply all these things on the award of rupees 19,000, so can get by. So there is no point for interference. Only they have not appeared in the claim case. They have not appeared in the petition under Order 9 Rule 13. Rule 13, but they have said that we came to know, and how they came to know, who has given the information. It is their burden to prove it. So nothing has been proven in that way. So the petition has absolutely no merit, my lord. They may be dismissed and the insurance company may be directed to pay the amount with interest within 1 month, my lord. Because he is the widow, he has not received a single money for death of her husband, my lord.
Yes.
So the basic, first one is a judgment, lordship. I'll come to the point that he has mentioned about
On that point, my lord, I am not agitating it. Actually, this petition is not maintained. When the petition under Order 9 Rule 13 is rejected by the trial court, then it is an appealable order under Order 43 Rule 1, my lord. So it is an appealable order. So against that order, they will have to file appeal first.
Yes.
And
This, on perusal of the grounds in your present appeal,
Yes, lordship.
it looks like an appeal under that provision, not an MSC appeal against the judgment.
Lordship may just come to the.
first they will have
This
to
case is
satisfy that
proceeded
order, my
in
lord.
violation of.
That order that has been read out just now,
Yes, lord.
this appeal is against that order substantially. In substance, it is an, because I peruse the, or not, you have not taken a single ground as to why the MSCT court was wrong in making the award. Not a single whisper about that.
Lordship, I may be allowed to, I'm given 2 minutes.
I am not agitating that point. Matter is an inordinate delay, my lord. Again, they file the appeal and again it will be remanded back.
If you had preferred this appeal on the merits of the judgment, then of course that's a different thing. But you have not made a single ground on that count.
Lordship may see my grounds of appeal, lordship. This, lordship, maybe it may suffer from technicalities.
You can't
But
escape
whole
by saying
this
that.
case proceeded, lordship, against
See,
the
for-
principles
for-
of natural justice. I has not even served a notice. And all the wrong averments are there in the judgment. They say that I have received notice. It is not there. Lordship may see the orders and Lordship may yourself come
No,
to
we
the
can
conclusion.
we can hear
This
all those submissions
proceeded
provided
without-
you had filed an appeal against that order. But you have come against the judgment now.
This appeal judgment,
If you
and
come
also
against
the
the
order
judgment,
dated,
you have-
Lordship, judgment award dated 9/4/2018.
Yes, you have
and
to point
order
out what is
20
wrong with that judgment. Not because of this non-appearance, non-receipt. That you ought to have
I have
executed
challenged
elsewhere.
both, Lordship. Judgment award dated 9/4/2018 and order dated 26/2023, both.
Show me the ground. Ground number 2.
Ground number.
Never received notice. Ground number 3.
Yes, Lordship.
Notice issued in wrong address.
Yes, Lordship.
Ground number 4. Absence of insurance company.
Yes, Lordship.
Ground number 5. Address incorrect. Ground number 6. Ought not to have dismissed the application under Order 9, Rule 13. So where is your ground of on merit of the judgment?
On a merit lordship, if the judgment basis is basically wrong, then I think the merit would not matter, lordship. This judgment, I am saying that this judgment ought not to have been passed because no notice was ever served, lordship. It's very clear.
No,
The address is wrong.
see,
There's
see,
no-
see your
no-
ground number 6. For that, the learned member ought not to have dismissed the application under Order 9, Rule 13 of the Code of Civil Procedure. So against that, what is the remedy?
In order and rule 13, they have to establish that they have not received notice.
That part, it may that particular part, lordship, that how we have received the notice, it may come through any source, lordship. That somehow we say that we immediately.
Any book written by you? Any provision through which you can come in any way? Huh?
Something like that. Looking
When
at
something is
came to me
provided in
that
the
such a
applicable
judgment is-
procedural law, can you say it can come in any way?
That can be, lordship, maybe lordship, they failed to declare that, so how?
What is the amount? What is the award?
And it makes something like that.
90,000.
Lordship, basically facts is there is no policy in this case. I'm not going to merit because I'm not going to merit. Firstly, as this matter is heard in my absence, and lordship without giving any notice to me. If that is such a substantial violation of the law, lordship, how can a judgment be passed against me without even giving notice to me? I think rest would all will pale into insignificance, lordship. This point needs to be considered first. How could this such averments have been made in the judgment that I have received notice when there is no proof of having received notice? When the address was wrong. Because if this finally ends of justice is to be made, and this is the point to be considered. Maybe rest will be technical,
in the order.
How can any case be decided against a person when he has not been served with a notice?
In the order and rule 13 petition, they have to establish that they have not received, but that did not appear, my lord. They did not appear.
I'd say, lordship, is a technical.
filed the petition, but did not
Compared to
appear.
the basic violation that I have not been served a notice, that probably would become secondary, lordship.
Or not receiving.
Primary is
filed petition.
primary.
They have to prove it.
No, that is there in the records itself. All the records will lordship a perusal record so that it was never said that it has been received. It said, no, since the case is pending, we will proceed. First, they notice, let's say, I'll read the observations, lordship. They're very serious observations. I'll read the observations, lord. Let's say when we come to para number 4 of my memo. What the learned member acted arbitrary and illegal in passing the order dated 27/10/2027. The order dated, lordship, on the ground that since the insurance company was absent without steps, and therefore the case shall proceed ex parte against the insurance company. It is stated that in the order dated 5/9/2007 is very clearly mentioned. Notice issued to OP number 3, Apple Insurance Company, was returned without proper service. Lordship, there is also a direction to take fresh steps on all the opposite parties and fixing.
Yeah, that is why you approach under for setting aside the order.
Yes, that's why I had approached.
Yes. So that has been dismissed. So against that, you should have come in appeal against that order under the CPC, not by way of an MSC appeal.
Combine both, lordship. Maybe, lordship, for the answer justice, we should consider how can a person be made to pay on technicalities when the notice was not served on him.
Procedural law is not such a plaything, Mr. Counsel.
I know, but substantial justice is also more important than procedural law, lordship.
Yes, everybody says that.
Will decide there is something if the insurance company has to pay.
In a court of law, there will be procedure.
For social
But
justice.
social justice will come later. Deliberately, lordship, notice was not served, lordship. Because there is no policy. Deliberately. I may be allowed to finish. I may be allowed to finish.
Award has been delayed.
I may be allowed to
For
finish.
last 10 years, 15 years.
Deliberate, because there is no policy in this case, lordship. All this is deliberately done to keep me away from the proceedings.
So what is the finding regarding policy in the judgment?
There cannot be any finding, lordship. Because I have not been allowed to deny that there is no policy.
It is mentioned in the judgment, but policy was in existence.
It will depend, the correctness of that finding will be, if I say so that it's admitted, I admit the policy, I deny the policy. There's no policy, there are records to that effect, lordship. I can produce records to that effect. There's no policy. They have deliberately kept here some documents. If the Caesarly says so, the policy is out of that. The Form 54 says so for policy update, but these are not there in the records. There is deliberately some attempt to keep the insurance company away from this notice.
I filed a petition order and ruled her, I am to prove it, that I have not received the notice.
No, that's the only point
They-
the
they
learned
have not
council
appeared.
below failed
They
to
have
do.
not appeared and come to
But
court
that,
for making
will
it
that
for
affect
under
the
10 years.
substantial cause of justice, Lordship? The person cannot
No,
be
it is-
penalized without hearing him.
Delay the woman.
Maybe
has
that's a,
suffered-
that I'd consider as
So
a
has
secondary to the primary, Lordship.
Let the,
Primary is that I have been penalized without giving notice.
let the insurance company recover it from the lawyer who failed to appear.
I'll leave it to you. Basically, in that case, everyone will try to do that. Keep the insurance companies away when there is no policy. That's what they have done deliberately. There is no policy and they deliberately did it. There's a owner is of All India. They could have gone against the owner also.
Policy has been taken by this trial court.
There's no record of notice being served on the owner. Even that ID card is not there. There's not a single ID card there in the file which says that so something grossly wrong has happened in a trial court. Subsequently, on technicalities, someone filed exam that is not there. But basic fact is that this will be violation of principles of natural justice.
Yes, anything else?
No more.
All right, TV.
Policy was valid, my lord. Obligation.
Itu. 16. IA. Yes, call. Channel. Who is there? You are there.
Item is 14. Just now has
14.
I has received now. Maybe taken at 2 p.m.
This is what?
I
This
have-
is 16.
Not 14. My
This
case
is 14. Negi. So this is the IA.
Yes,
IA has
14,
come.
item number 14. Yes, ma'am. I this IA
For what?
because of my inadvertent mistake. Because in the year 2018, when the case was come, there is a 3 petitions by MSc appeal and stay application and also as well as IA for delay. And that time all the cases were registered. Generally, my lord, until and unless the delay is not unknown, MSc appeal and also stay petition was not registered. So that is my mistake. This honorable court has passed, but I inadvertently state that.
But we have to issue notice first.
Well, my lord, if lordship issue notice by paper publication because it is an old pending case, I'll take the step order 5/20 CP
Now, straight away, how can you say paper publication?
only for owner and drivers. Payment was already appeared. It will be good for us. We have taken also once upon a time because it will be.
All right, IA number 652 of 26. This IA has been preferred seeking verification of the order dated 23/10/19.
My lord.
Passed by this court in IAC number 3617 of 2018. Learned respondent number 1 is already represented in the
Clearly.
connected
2 and 3, owner and driver. Already they are
appeal.
completed.
Therefore, it is prayed that the applicant may be permitted to notice by way of paper publication in addition to usual mode. Having regard to the fact that the respondents number 2 and 3 are the owner and driver of the offending vehicle, the prayer is allowed. The petitioner shall take steps by
within 15 days, paper
way
publication.
of substituted service by publication in two newspapers, one English and one vernacular,
My lord, they are
circulating in
all, my lord, NC Hill. 2 and 3 are residential
circulating in
local paper.
Hill means what in Assam.
Yes,
I
yes.
don't
that
think
is
there is
why-
any specific paper in NC Hills
My lord, not.
circulating in the state of Assam. Should we mention the paper?
My lord,
Two daily including two daily newspapers, including the Assam Tribune, and you say
my lord, one vernacular, my lord, Proceeding, like this,
Proceeding Times.
because it is widespread.
Yes. Shall also take steps by speed post AD.
My lord.
It's number 2 and 3.
My lord, I file an affidavit also.
And
after the
file affidavit, petitioner shall, applicant shall file a necessary affidavit after causing paper publication.
My lord. Well, IA is 10 disposal.
I stand disposed of.
My lord, I'm.
No, IA means
This IA,
where will you file the affidavit if the IA is disposed of?
my lord, this is order is passed, order is 2310. If it is set aside, then automatically I'll take the step. That is,
You have to submit a affidavit of publication
my lord. No.
along with copy of the paper.
Yes, yes.
So if the IA is disposed of, where will you file?
I'll, my lord.
Let the IA be pending then.
Yes.
You have to file it here.
Yes, yes, I did.
At least again on.
I missed the item and I was and Lordship was pleased to the way but the practical could not come here. And my senior was in leg on other courts. It's a petition for condition of delay. A long pending matter, Lordship. Kindly convince me, so next week I will complete.
Okay, please, item number 4. None appears, list the matter on Friday. That day you will.
Next Friday. Not next week, Friday. What is
Give it on Monday then.
and Monday will not be available, Mr.
If I give a date then.
6 after Holi.
All right. 6.
Obliged.